Welcome to Hull and Estate and Succession Planning, a series of podcasts hosted by Ian Hull and Suzana popovic-montag. The podcast you are listening to will provide information and insights into estate planning in Canada. From the offices of Hull and Toronto, here are Ian and Suzana.
Hi, and welcome to Hull and Estate and Succession Planning. You're listening, and some of you may be watching, episode 167 of our podcast on Tuesday, June 2nd, 2009. Hi there, Ian.
Hi, Suzana.
How are you today?
Terrific, thanks.
That's good.
So today we are continuing with our theme, which my grade 13 English teacher taught me, and that was be specific. And she always used to write all over my essays, BS. And at first, I didn't know what that meant until I pushed her on it. But we are being specific about costs. Instead of just making the blanket comment, it costs a lot. We're trying to really drill down on it and educate ourselves and to rethink why it costs so much, talk about some of the tangents it will go on, and B, really identify with some specific, or what we might say, we want to BS, and we want to be specific, and we want specificity, or whatever the word is. What is the word?
Specificity.
Specificity. Say thank you. I can't even spit it out. That's why I always stick with BS. And talk a little bit about it. And I think on our last podcast, I sort of cut short on the motions, and I think we want to explore a little bit more of that, because that really is one of the areas that demonstrates the complete chaos a lawsuit can go into. I mean, I've had cases, and you've had cases, where motions, we could have 7 or 8 motions, 10 or 20 motions. So it's that, of course, turns a lawsuit into a marathon. And so from that standpoint anyway, why don't we spend a little bit more time on some of the illustrations so that we can get a better handle on that, and then maybe talk about some of the wind-up steps if we have time. If not, we'll do it on our next podcast. So let's come back to, although I promised we were finished on the motions, let's come back to that and let's walk through some of those.
Well, Ian, we did talk about some of the emotions that we can sort of, as counsel, I think, predict might arise in a situation once our clients have told us the facts as they sort of know them as best as they can. And then there's some of the emotions that just arise, as you said earlier, for strategic reasons, or may arise just because something has come to light that we weren't aware of, and that there may be a way that we could start to use that to our advantage. And what I'm thinking, for instance, is that sometimes in a will challenge situation, you're facing a limitation period. You may have an individual who's challenging a will, but also deciding whether or not they want to make an election under the Family Law Act, for instance. And in that case, we may have a motion to extend the limitation period to bring that proceeding until further investigations are done in the will challenge side. So that's one of those illustrations of you may have thought about, but you wouldn't necessarily expect to arise right from the get-go when you're meeting with clients.
And before we go to the next one, that one is a good illustration of a motion that has to be brought for the interest of the parties. And it's not really we were talking about strategic motions. That's not a strategic motion. That's a investigative, information gathering motion in that sense. So in a way, although it can be time consuming and irritating to the process, it's actually one of those, I would call it, good motion.
Right.
That's to be specific.
Similarly, I think one of the motions that would arise, again, in these kinds of situations where more and more evidence unfolds, is one to add further parties to the litigation. And
So what do you mean by that?
Well, if it turns out that there's someone who should be part of the proceeding and isn't named at first instance, either because you didn't know of that individual, or possibly another potential beneficiary under an estate, or as investigations unfold, maybe it turns out that some of the professionals who are involved in the estate planning ought to perhaps be added to the litigation, then a motion is actually required to have them added as a named party litigant, and so that rights of discovery and rights of information gathering and other remedies can be sought against that individual at the end of the day.
And so on that kind of a motion, it's sort of the combination, because it might be strategic to add that party. For example, you may want to add the accountant or someone who was involved in the estate planning because you've unfolded that information. Oh boy, the accountant was a lot more involved than I was.
That's right.
Or you might want to add the accountant for strategic reasons as well. So you've got sort of good and bad on that sense. I mean, there's never a bad motion, of course, but a good reason to add the party because they are a proper party, and maybe for strategic reasons you're also wanting to add the person. And so that motion, again, tough to predict until the file unfolds, so tough to predict the cost of that. brings more uncertainty to the process, but is really a necessary evil of the process.
And I know, Ian, you and I have recently dealt with a matter where we've actually consolidated two different pieces of litigation. And that's another motion that, again, at the very outset, you might not have expected to arise or to be required, but something that strategically makes sense as things unfold as well.
Right, and in that situation where consolidation could occur, you might have a situation where you've got to sort of interpret the will or understand what the will means, but at the same time bring in claims. Maybe someone's owed some money, maybe a creditor is out there, and you think, well, look, you know what, we're going to go to court, let's try to do this all at once. Right. So you bring in this sort of, come to court and say, let's just consolidate this all. So the judge is going to hear the same story once, and then each complainant or each person in the process will be able to interject their spin on the story, and then you have a lot more efficiencies.
That's right. That's right. And another illustration that we see where motions can arise, whether expectedly or unexpectedly, is situations where the estate has a holding company or corporate assets or corporate shares, and for instance, someone needs to run those corporations while there's a will challenge going on. So we've seen interim receiver motions being brought. We've seen injunctive motions being brought to freeze parties from doing things, or to prevent parties from doing things, to freeze certain assets, to freeze certain transactions from happening as well.
Okay, and those motions really, they bear both the combination, sometimes a necessity, sort of administrative necessity, but also can be a tremendously impactful strategic move. When you tie up a corporation or you take control of the corporation away from an individual in the course of the litigation, that sometimes makes people crazy.
Right.
So I can see the advantages on both sides of that.
And it's with that wide gamut of the kinds of motions that can arise during just even what we call a basic will challenge. And that's why we're giving clients parameters of, it could cost somewhere from $50,000 or from $5,000 to $50,000, depending on how litigious the motion is, how much information is required in order to put your best foot forward and try to win that motion, and depending on how important it is to the client to win that motion.
Well, those are really helpful illustrations of the ongoing uncertainty of stepping into litigation. And one of the things, too, of course, is that we don't know what's going to drive the motivation. It's sometimes the client, it's sometimes the professionals, it's sometimes the advisors who is actually sort of pushing the buttons. And sometimes you have a client who is sort of respectful of their advisors, and so they don't really push back on these things. And so the advisors sometimes develop the strategy as opposed to the client, or vice versa. The client is coming in, vim and vigor, saying, I want to show my sister, who's boss, I want to teach her a lesson, how do I do it?
Right.
And the lawyer might say, well, look, there are strategic buttons we can push, but there's also information buttons we need to push. So let's pull it into a whole ball of wax so that we don't look like we're just bullies in the street to the judge. But at the same time, we're also sending a clear message that litigation is no fun, and it's not for the faint of heart.
That's for sure.
So those illustrations really help us develop that and bring us back to our ongoing and central theme, and that is, of course, why the heck get involved in the litigation process unless you absolutely have to? Because, being specific, we are seeing more and more examples of uncertainty, costs, and emotional uncertainty. So, all right, well then, before we wrap up the costs process in our final podcast on BS, we'll get specific on just the last component of the process, again, to try to get some illustrations and demonstrate the costs and uncertainty with that. So thank you very much for joining us today.
Thanks very much to you too, Ian.
Thanks, Suzana.
You have been listening to Hull on Estate and Succession Planning by Ian Hull and Suzana popovic-montag. The podcast that you are listening to has been provided as an information service. It is a summary of current issues in estates and estate planning. It is not legal advice, and you're reminded to always speak with a legal professional regarding your specific circumstance. To listen to other Hull & Hull podcasts or leave any questions or comments, please visit our website at hullestatemediation.com.